Hi, everyone. Welcome to the ABA Compliance and Legal Series, where we explore the legal realities that shape how ABA practices grow, operate, and stay out of trouble. I'm your host, Tzvi Weiser, with NUCO Filings. We help ABA owners and investors form and structure their businesses, LLCs, MSOs, and multi-state filings so they can scale without legal friction. This series was born out of a simple insight. Legal issues aren't edge cases anymore, they're daily decisions. And when it comes to compliance, there's no bigger pressure point than HIPAA. Not just for ethics, but for risk, deal value, and survival. That's why I'm honored to kick off the series with someone who doesn't just know the space, he shapes it. Roger Cohen is a partner at Goodwin, where he advises national healthcare and behavioral health platforms on regulatory risk, government enforcement, and complex M&A. Roger, thank you for leading us off. Before we dive in, would you take a moment to introduce yourself and share a bit about your work at Goodwin?
Hi, Tzvi. Thank you for having me. It's nice to spend some time with you. I'm a partner at Goodwin, as you mentioned, in the healthcare practice here. I'm based in New York. I work with a wide variety of healthcare providers and digital health companies, including ABA providers on healthcare regulatory issues, counseling them on healthcare regulatory issues, including HIPAA. I also spend a good deal of my time working on transactions in the healthcare space.
And that's an important crossover because we're going to touch on that a little bit later. At the end of the day, we're all in this for one reason, and we want to make sure that whatever starts at HIPAA ends in the exit. Okay,
Absolutely.
So let's start off with a basic question. For a growing ABA practice, when you say comply with HIPAA, what does that actually mean day to day?
Sure. So there are a handful of basic items to check off that are required to comply with HIPAA. The first is appointing a security officer, someone who is overseeing compliance with HIPAA at the organization. It doesn't need to be someone who is devoted to that position full time, but someone has to oversee compliance with HIPAA. The next sort of basic box
Let me
to
just
check.
stop you for a second because I want to make
Sure.
this as practical as possible. Who in the organization would that typically be? Would it be a legal counsel, H&R?
It's often if there's in-house counsel, commonly that person, if there's someone who oversees IT, sometimes CFO or someone who oversees HR, and it can be any one of those people or other people within the organization. The idea is to have someone who understands HIPAA and can oversee compliance with HIPAA.
Is this a big job or is it just monthly or weekly overseeing and just reviewing?
Yeah, I think it depends on the nature of the organization. It'll be different for, say, a national ABA provider with locations across a number of states versus an ABA provider with a single location. For a smaller ABA provider with a single location, I would not expect this to be a full-time job. Yeah, I think it's something you would devote a couple hours a month to, with peaks and valleys. There are times when you might spend more time if you're doing a risk assessment, adopting policies and procedures, or reviewing your policies and procedures. When you're doing training, those kinds of things may take a little more time, or if there's some sort of breach or security incident. But in the ordinary course, I just make sure you're on top of things and doing the things that are required.
Okay, so I interrupted you. In terms of day to day, you're saying that it depends on the organization, and what does it entail?
I think the question here is what's the position of the security officer entail. I think point one is ensuring you are doing the things that are required to comply with HIPAA, and we'll come to the other pieces of that, and we'll talk about a risk assessment, adopting policies, providing training, having safeguards in place as well, among other items. That's the first piece of it. And often you'll work with, I wouldn't expect the person who is the privacy and security officer to necessarily be an expert on what you need to do to comply with HIPAA, to draft the policies themselves. You'll work with outside advisors typically on those kinds of things. But that's the first piece of it, ensuring you're meeting the requirements to comply. Then another piece of it is overseeing issues. If there is a data breach or a security incident, really being the point person for that, being a resource within the organization if there are concerns about compliance with HIPAA, or if someone is lost a phone or a laptop that has PHI, to be the sort of contact person for those kinds of items. That's another piece. Leading education and training in the organization around HIPAA as well as another piece of that job. We'll talk about insurance as well. That person may be involved in reviewing insurance coverage related to cybersecurity as well.
Okay, so let's dive into risk assessment. What does that look like?
A risk assessment is really, and this is again another one of the sort of basic boxes you have to check to comply with HIPAA. And a risk assessment is an exercise in taking an inventory of the systems you use to store and process patient information, the risks to information in those systems, and what you're doing to mitigate the risks. So if you have an electronic health record system, for example, the risks are someone who's not authorized might get access. And what are you doing to mitigate that risk? You have unique logon credentials with a password and certain password sophistication requirements. That's an example of an item you'd have on a risk assessment. Are there other systems you use to process patient information, to communicate with patients, for staff to communicate? And you really go through those on a spreadsheet, put those down, look at the risks in each system and what you're doing to address those risks. HHS OCR, the regulator in this area, or the lead regulator of the Department of Health and Human Services, Office of Civil Rights, they have a template for a risk assessment available on their website. I recommend that as a tool to use for conducting a risk assessment. And maybe one point of emphasis here, an important element of a risk assessment is not just doing the risk assessment, it's documenting. Like many things, when you deal with the government and compliance, if it's not documented, it's as if it doesn't exist to the government.
You mentioned that you would work with outside counsel in putting together your compliance for HIPAA. What would that outside counsel provide the ABA organization?
So we work with clients on HIPAA compliance. One piece of what counsel will help you with is identifying what it is you have to do to comply with HIPAA and run you through the checklist. Maybe look at what you have in place, look at what you need to meet the requirements. And then a second piece of it is helping you meet the requirements. One requirement, you have to have written policies and procedures related to privacy and security of patient information. Lawyers can help with policies and procedures. Similarly, you need to have a notice of privacy practices under HIPAA. It's really a document you provide to patients and you post on your website that explains how a provider uses patient information, to whom it might disclose the patient information. Most counsel in this area will have forms for that document. HIPAA training, I sometimes help clients with HIPAA training. There are vendors who provide HIPAA training as well, but that's another requirement. The next thing I wanted to cover, business associate agreements. Like, this is another requirement of HIPAA. If you have vendors that receive or have access to patient information, an electronic health record company, a billing company, consultants who work on reimbursement or other issues, who may have access to patient information, you need to have business associate agreements with those consultants. And that business associate agreement's an agreement that specifies what the consultant or vendor can, how they can use and disclose patient information, what happens in the event of a data breach, those kinds of items. And so a lawyer in the area can help you with forms for those agreements. They can help you negotiate those agreements if they're negotiated as well. Those are really the primary areas. Maybe one additional areas, counseling, and I think we're going to cover this, but some of the areas where there's a little complexity around texting with patients. Certainly, if you have a data breach or security incident, helping to respond to that's another area where we work with clients around HIPAA.
So a small ABA firm, how much of this process can they do alone? You mentioned that the OCR has templates that they can work through. Is that sort of can cover what they need, or they would have to work with attorney, with outside counsel in order to make this happen?
We certainly see lots of clients who, when we're doing diligence in connection with transactions, who will tackle HIPAA compliance on their own, particularly if they have some experience in the area and they may have forms for policies and procedures and the notice of privacy practices and business associate agreement, and they can use the template risk assessment from HHS OCR. But I think it is helpful to work with a consultant or counsel on these items. I'd say more often than not, when clients are going it alone, doing it themselves, they don't get everything exactly right, and there's some gaps that need to be addressed. And typically, lawyers experienced in the area can help you efficiently to address those gaps.
Most importantly, if they did it themselves and they had these typical gaps that you see, what would happen in an audit? Would they be able to stand up through an audit, or would that cost them at the end?
So there's very little auditing by the regulators of compliance with HIPAA. There is some, but it's really extremely limited, unlikely to happen. I'd say the more typical scenario where you might get in trouble for not meeting the compliance requirements are, one, if you have a data breach, there are requirements to report the breach to the government. And sometimes the government will follow up and ask for information, do a little investigation. And when they do that, they always ask for the kinds of things we've discussed that are required: your risk assessment, your policies and procedures, your business associate agreements. And I have had clients that they've had breaches, and when you respond and you indicate you're complying with the requirements and doing the right things and you handle the breach in an appropriate manner, the government will say, okay, we're not going to penalize you. We're closing the matter without further action. But when the response is, we don't have them, we haven't done these things, or we just did them only after this happened, the government is more likely to pursue some enforcement action when that happens. The other sort of scenario.
I just want to ask the question that probably some operators are thinking. What requires you to report a breach? Obviously, that's the law. But if you didn't, wouldn't it be the same thing? Like, you don't get audited, who's going to ever know that there was a breach?
So there is a requirement under the law to report the breach. And the risk of not doing that is, one, you can, if it's discovered, if, for example, someone learns about it, you have an employee whistleblower, you have a patient who learns about it and goes to the government, you are in a much worse off position than if you go to the government yourself. Generally, the government looks favorably at people who come forward and report incidents and follow the law. And it does not when it sees companies that don't deal with incidents and then report them as required. And as you would imagine, it goes after those companies when it discovers that's the case.
But that becomes a very slippery slope, because if I don't have very good compliance, I haven't done all the things I have to do, and then there's a data breach, it would be almost suicidal to go forward, because at the end you will be penalized.
Not necessarily. I'd say in practice, there are often gaps. Compliance isn't not ever sort of, you infrequently achieve 100% and see every risk and address every risk. There are always risks, and there's always a possibility of human error that's not caught. And when you deal with it appropriately, when you try and fix, if there was an oversight, I think of a common fact pattern, there's an error in billing, and patient A gets a bill for patient B, or patient B gets something for patient A, or some other communication mix up like that. If you just do an analysis and understand what went wrong and try to fix it, and you and you report it to the government, and let's say maybe you didn't have policies and you now adopted policies, including a policy, or you haven't done training, and you do training and you adopt training. The government generally will not pursue enforcement action in those kinds of matters. And that's really the key, is if you have something that goes wrong, you deal with it.
Right.
And you do the right things that are required to address it and to remediate gaps.
Okay, let's go back to something that you mentioned briefly before: emailing and calling. What are the HIPAA risks around that?
Sure. So calling I'll start first. Generally fine. You can call patients and communicate with them over the phone. One slightly tricky area is around messages, and the idea there is you want to leave limited PHI in a message. This is so and so calling from ABC, ABA services. Please call us back. You don't want to leave more than that, and certainly avoid leaving any sensitive information on voicemail if you can avoid it. Email is a little different. Unencrypted email is considered not a secure means of communication under HIPAA. It generally doesn't comply with the security requirements to send unencrypted PHI via email, and that's either to a patient or internally. You can use encrypted email platforms. That's permissible. Unencrypted email is not allowed under HIPAA if it includes PHI, either with patients or internally with business partners. However, patients can opt into unencrypted. So if you have a process, say, in registration where a patient or family can check a box that they want to communicate with you via email or text, they understand it's unencrypted and there's a risk that messages may be seen by unauthorized persons, fine, and they check the box on that, then you're fine. Then you can have unencrypted text or email with patients.
Right. What about employees using their own personal devices for communication with parents? Is it something that the company has to provide everybody with an encrypted device, or they can use their own?
From a security perspective, certainly you can have a bring your own device policy where employees and staff use their own devices. You generally would want to have software to ensure security on those devices. That software is very common. And if you allow your staff to use their own devices to text with patients or text PHI, you want to have that software on the device. I was going to flag one other issue that comes up a lot with email and text is what happens, well, a patient emailed us or texted us, and patients are allowed to do that. If they choose to do it, it's their right to do it. Generally, you want to have a policy on that and what you do in those circumstances. You can have a policy where you can respond and keep your limited PHI in the response is a common approach to that. Some providers will have a more stringent policy. It's not necessarily required that we're going to try and take the communication to another channel. And those are the common approaches to that situation.
So if a parent writes to the therapist, does that mean that they opted out of privacy?
Effectively, yes, with respect to that communication. I wouldn't take the position that if a parent emails once, you can then forevermore communicate with them via email and text. I would generally want the parent to check the box that they authorize they want to opt into email or text communication. I think of it as you can answer that if they email or text without having checked that box, you can respond to that email or text.
Let's talk about subpoenas and discovery requests. What should a clinic do if they ever get such a request? What's the mistake that they typically make when they get it?
So my recommendation is talk to a lawyer if you get legal process like a subpoena or a discovery request, but both because HIPAA comes into play and you want to comply with HIPAA, and because you may need advice about the litigation or whatever legal process is going on. And I think a good idea to get advice in that situation. Dealing with the HIPAA issue, the general rule under HIPAA is you can't disclose patient information without patient authorization, except for certain limited purposes like treating the patient, billing insurers for your services, and running the business. There are exceptions for subpoenas and discovery requests. They are a little complicated, which is why I recommend talking to a lawyer. The general rule is a court-ordered subpoena. You can disclose records in response to a court-ordered subpoena. Discovery requests are different. You can have an attorney, I can send in a litigation, I can send another party a discovery request. It's not signed by a judge, approved by the court. And In that case, you can't disclose protected health information unless there's a protective order in place in the case, or there's a notice process that's been followed through and the patient hasn't objected. And so generally in that situation, when a client reaches out to me when they've received a subpoena or discovery request, I want to look at the subpoena or discovery request and assess, is this court ordered and can we produce the records? If it's not, are the other requirements that have they been met such that we can produce the records? If they haven't, I generally will have a conversation with the lawyer on the other side and tell them we can't produce the records. Often I try to be cooperative and tell them we want to cooperate. We have legal obligations. We need to follow the law, and here's what you need to do to enable us to produce those records to you.
So we're not talking about an audit about HIPAA. We're talking about just a lawsuit that's not related to HIPAA. Is that correct?
Correct.
Okay. So if it was HIPAA related, if it was an audit, it would be ironic to think that you can't answer it because you'll now violate HIPAA.
And there is one requirement under HIPAA. You're required to keep your records related to compliance with HIPAA, and the government can ask you for those documents. That in that case, you're allowed to disclose those records to the government under HIPAA.
Let's talk about an area that I think is pretty misunderstood, addressable versus mandatory when it comes to HIPAA.
So HIPAA has two categories of requirements, addressable and required. And the addressable requirements are optional, but optional with an asterisk in the sense that you don't have to implement the safeguard if it's addressable. But if you don't, you have to document the reason you're not implementing the safeguard. And so, for example, there are requirements around physical security and limiting access to a facility. And you may look at that requirement and say, our facility is located in we have a suite in a building, there's limited access to the building, and so we don't have security beyond that. And so we're not implementing this addressable requirements related to physical security. That's an example of where that might come up.
What are typical reasons for not addressing it that people think or use that aren't actually legitimate?
We don't want to do it is not a good reason for not implementing an addressable safeguard. The good reasons, or the acceptable reasons for not implementing addressable requirements, are it's met in some other way, like the physical security example I gave. Another one may be cost and expense of taking the step versus the benefit of implementing the safeguard given the nature of a business. For example, you have a third-party electronic health record. It's a SaaS service. It's online. You don't have physical records outside of that. There may be requirements that don't add a lot to security that you might identify that are addressable and might not implement. You document your reason. There's limited risk. There's cost for implementing these requirements. And so we're not implementing this requirement for that reason.
Flat out cost is not going to do it. It's cost versus we have just a very minor risk of breach.
Correct.
Let's talk about something that we're all hoping for one day, an exit. How does HIPAA come into play when you talk about due diligence for a buyout?
Whenever you're looking at a buyout, someone like me is going to conduct due diligence, and I'm going to ask you for all of the things, that documentation of all the things that are required to comply with HIPAA. Who's your security officer? Give us a copy of your risk assessment. Give us a copy of your policies and procedures, your notice of privacy practices. Show us documentation of your training, the materials, and who did it when. Give us copies of your business associate agreements. And I'm going to go through the checklist and look at if you have all those items. I'm going to look at the documents themselves. Is the risk assessment, is it the kind of risk assessment that the government will find acceptable? How old is it? Systems change, risks change. You should probably think about doing a risk assessment annually, something like that. Are your policies and procedures Do they really cover what they're supposed to cover, or are they very limited? You should do training again on hire and annually. Are you doing it? Has everyone done it? And so I'll look at all those kinds of things, certainly. And if you're not meeting all those requirements, we'll look at remediating them. Maybe we'll have a covenant in the agreement that requires you to remediate these items. There may be indemnification that comes into play. We'll also want to understand whether you've had data breaches or security incidents. If so, have you responded to those appropriately? Again, if you have had an incident and you haven't responded appropriately, that's going to be a big concern in a transaction. And then we'll look at some of the.
How so? What's
Sure.
What's the risk exposure going backwards for a buyer?
I am always, if I'm a buyer, I'm concerned that I am taking on a liability for something that happened before I acquired the business, and I don't want to have that liability. And so I'm going to want generally either protection in the form of indemnification from the buyer. Often in transactions these days, there's something called rep and warranty insurance. It's essentially an insurance policy saying that everything you've promised me in the purchase agreement, that you've complied with the laws, among other things, is true. And if there's some liability for breach of those warranties, the insurer will make me whole and the policy will kick in. And when you have an identified issue like a data breach, there's an exclusion. The policy doesn't cover that. And so I'm going to want to look to the seller to make me whole and to protect me from that liability.
So I assume if it's a personal lawsuit from a patient, then they don't really care that it was sold. But from a government standpoint, would they penalize a company when there was a data breach 2 years ago with a different owner?
Absolutely. Some of this depends on transaction structure. So if I'm buying the stock of a company, then as far as the government is concerned, and as really as a matter of law, it's the same company, same tax ID number, just a new owner. And it's the company that's liable for violating HIPAA. And so the government would penalize the company, and it would come out of the pocket of the new owner, though.
Is that how transactions usually work in the ABA business, or do they actually sell the assets and the operations to a different LLC?
Transactions are often structured as stock purchase agreements. There's certainly from the seller's perspective, it's beneficial from a tax perspective to have a stock transaction. You can pay taxes as capital gains as opposed to income. In an asset sale, you don't have that tax benefit, so you'd prefer to do, as a seller, a stock transaction. Sometimes you will do an asset purchase. There is complexity also in healthcare and ABA businesses. When you do an asset sale, do your insurance agreements move over? Does your Medicare participation move over?
Sure.
And there are more hurdles when you do an asset sale as opposed to a stock purchase.
Right. That means you would have to
in a healthcare
re-credential
business.
everybody and the company.
Correct.
So for a closer, you just guessing on the audience out there and the type of breaches that there are, the type of liability or exposure that ABA companies have. We're talking about small ABA companies, maybe some of them have a few states. What would you recommend 2-3 fixes that can be done within the next 60 to 90 days?
I think risk assessment, policies, and training. You should look at, do you have a risk assessment? How recent is it? If it's more than a year old, you should do a new risk assessment. Do you have written policies and procedures? What do they look like? If they're 1 to 3 pages, you should work with a lawyer or a consultant to get more comprehensive policies in place. Are you doing training on hire and annually? If not, you should do that. Those are basic building blocks of HIPAA compliance. If you ever have a data breach and the government investigates, they will ask for those things. If you're looking at an exit, the buyer is going to ask for those things. They're fairly easy boxes to check, and it's beneficial to check the box.
Okay, great. Thank you, Roger. That was incredibly valuable. Thank you for setting the tone for the series and walking us through what HIPAA compliance actually looks like inside an ABA practice. From texting and subpoenas to risk assessments and deal red flags, this episode delivered the kind of insight most owners and advisors don't hear until it's too late. If you're in the ABA space as an operator, startup, or investor, this series is built to help you stay ahead of the legal curve. And if your structure needs attention, whether it's forming a new LLC, managing compliance, expanding your MSO, or cleaning up your filings across states, that's what we do at NUCO Filings, quietly and behind the scenes. Check the link in the show notes or reach out anytime. If today's episode gave you clarity, share it, subscribe, and join us for the next conversation. Until then, stay sharp, stay compliant, and we'll see you soon. Thank you, Roger.
Thank you, Tzvi.